beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has proven each of the elements of the crime charged beyond a reasonable doubt, you should find Mr. Woodyard guilty of that crime. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements of the crime charged beyond a reasonable doubt, you should find Mr. Woodyard not guilty of that crime. Number 4, a fact may be proven by either direct or circumstantial evidence. Under the law, both are acceptable ways to prove something. Neither is necessarily more reliable than the other. Direct evidence is based on firsthand observation of the fact in question. Circumstantial evidence is indirect. It is based on observations of related facts that may lead you to reach a conclusion about the fact in question. Number 5, you are the sole judges of the credibility of each witness and the weight to be given to the witness's testimony. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. For each witness, consider the person's knowledge, motive, state of mind, demeanor, and manner while testifying. Consider the witness's ability to observe, the strength of that person's memory, and how that person obtained his or her knowledge. Consider any relationship the witness may have to either side of the case and how each witness might be affected by the verdict. Consider how the testimony of each witness is supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence when you evaluate each witness' testimony. You are not bound by the testimony of witnesses who have testified as experts. The credibility of an expert's testimony is to be considered as that of any other witness. The weight you give an expert's testimony is entirely your decision. You may believe all of the testimony of a witness, part of it or none of it. The number of witnesses testifying for or against a certain fact does not by itself prove or disprove that fact. 6, during the trial, you have heard and seen sound and video recordings of certain conversations. These conversations were legally recorded. They are a proper form of evidence and may be considered by you as you would any other evidence. The recordings themselves are the evidence. If you noticed any differences between what you heard on the recordings and what was said during the trial, you must rely on what you heard on the recordings. You must keep in mind that what is on the body camera footage does not necessarily represent or depict what a particular individual at the scene saw or heard during the recorded events. It is for the jury, to determine what was heard and said. 7, Mr. Woodyard is charged with the crime of manslaughter reckless. The elements of manslaughter are 1, that the defendant, Nathan Woodyard, 2, in the state of Colorado, in Adams County, on or about August 24, 2019, up and through and including August 27, 2019, recklessly, 4, caused the death of Elijah McClain. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant, Nathan Woodyard, guilty of manslaughter. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant, Nathan Woodyard, not guilty of manslaughter. Number 8, if you are not satisfied beyond a reasonable doubt that the defendant, Nathan Woodyard, is guilty of the offense charged, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the offense charged, if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The offense of manslaughter reckless as charged in the indictment in this case necessarily includes the lesser offense of criminally negligent homicide. The elements of the crime of criminally negligent homicide are 1, that the defendant, Nathan Woodyard, 2, in the state of Colorado, in the county of Adams, on or about August 24, 2019, up through and including August 27, 2019, 3, caused the death of Elijah McClain, 4, by conduct amounting to criminal negligence. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser included offense that is necessarily included in any offense charged in the indictment. The law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide that the prosecution has proven each of the elements of manslaughter or reckless, you should find the defendant, Nathan Woodyard, guilty of that offense, and you should so state in your verdict. After considering all the evidence, if you decide the prosecution has failed to prove one or more of the elements of manslaughter or reckless, then you must decide whether the defendant, Nathan Woodyard, is guilty or not guilty of criminally negligent homicide. After considering all the evidence, if you decide the prosecution has proven each of the elements of criminally negligent homicide, you should find the defendant, Nathan Woodyard, guilty of that offense, and you should so state in your verdict. If you decide the prosecution has failed to prove one or more elements of criminally negligent homicide, you should find the defendant, Nathan Woodyard, not guilty of that offense, and you should so state in your verdict. While you may find the defendant, Nathan Woodyard, not guilty of manslaughter, reckless, and criminally negligent homicide, you may not find the defendant guilty of more than one of the following offenses: reckless manslaughter or criminally negligent homicide. Number 9, for manslaughter or reckless, a defendant may be either a principal or complicitor. Complicity is not a separate crime. Rather, it is a legal theory by which one person may be found guilty of a criminal offense that is committed by another person. For the defendant, Nathan Woodyard, to be found guilty as a complicitor of the crime of manslaughter reckless as defined at the end of this instruction, the prosecution must prove each of the following conditions beyond a reasonable doubt. 1, another person or persons committed the crime of manslaughter as defined at the end of this instruction. And 2, the defendant, Nathan Woodyard, with the desire or the purpose or design to aid, abet, advise, or encourage the other person or persons in planning or committing that crime. 3, aided, abetted, advised, or encouraged the other person or persons in planning or committing that crime. And 4, that the defendant, Nathan Woodyard, was aware of element numbers 1, 2, and 3 of that crime as defined at the end of this instruction. For purposes of this instruction, another person or persons committed the crime of manslaughter reckless if the prosecution proves each of the following elements beyond a reasonable doubt. 1, that the other person or persons in the state of Colorado and the county of Adams on or about August 24, 2019. 3, recklessly. 4, caused the death of Elijah McClain. After considering all the evidence, if you decide the prosecution has proven each of the conditions of complicity liability beyond a reasonable doubt, you should find the defendant, Nathan Woodyard, guilty of manslaughter reckless after considering all the evidence. If you decide the prosecution has failed to prove any one or more of the conditions of complicity liability beyond a reasonable doubt, you should find the defendant, Nathan Woodyard, not guilty of manslaughter reckless. 10, the prosecution alleges that Mr. Woodyard is guilty of the crime of manslaughter reckless as a principal or as a complicitor. You have received separate instructions regarding these two theories of liability. Instruction 7 describes the principal theory of liability, and Instruction 9 describes the complicity theory of liability. You should consider the two theories separately. Your determination of whether Mr. Woodyard is guilty of the above referenced crime as a principal should not affect your determination of whether Mr. Woodyard is guilty of the above referenced crime as a complicitor. Similarly, your determination of whether Mr. Woodyard is guilty of the above referenced crime as a complicitor should not affect your determination of whether Mr. Woodyard is guilty of the above referenced crime as a principal. You may find the defendant not guilty of the above referenced crime under both theories of liability, principal liability and complicity liability. Or you may find the defendant guilty of the above referenced crime as a principal, as a complicitor, or both a principal and a complicitor. 11, for the crime of criminally negligent homicide, the defendant may be either a principal or a complicitor. Complicity is not a separate crime, rather it is a legal theory by which one person may be found guilty of a criminal offense that is committed by another person. For the defendant, Nathan Woodyard, to be found guilty as a complicitor of the crime of criminally negligent homicide, as defined at the end of this instruction, the prosecution must prove each of the following conditions beyond a reasonable doubt. One, another person or persons must have committed the crime of criminally negligent homicide as defined at the end of this instruction. And two, the defendant with the desire or the purpose or design to aid, abet, advise, or encourage the other person or persons in planning or committing that crime. Three, aided, abetted, advised, or encouraged the other person or persons in planning or committing that crime. And four, the defendant was aware of elements 1, 2, and 4 of that crime as defined at the end of this instruction. For purposes of this instruction, another person or persons committing the crime of criminally negligent homicide if the prosecution proves each of the following elements beyond a reasonable doubt. One, that the other person or persons do in the state of Colorado in the county of Adams on or about August 24, 2019. Three, caused the death of Elijah McClain. Four, by conduct amounting to criminal negligence. After considering all the evidence, if you decide the prosecution has proven each of the conditions of complicity liability beyond a reasonable doubt, you should find the defendant guilty of criminally negligent homicide. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the conditions of complicity liability beyond a reasonable doubt, you should find the defendant, Nathan Woodyard, not guilty of criminally negligent homicide. The prosecution alleges that Mr. Woodyard is guilty of the crime of criminally negligent homicide as a principal or as a complicitor. You have received separate instructions regarding these two theories of liability. Instruction 8 describes the principal theory of liability, and Instruction 11 describes the complicity theory of liability. You should consider the two theories separately. Your determination of whether Mr. Woodyard is guilty of the above referenced crime as a principal should not affect your determination of whether Mr. Woodyard is guilty of the above referenced crime as a complicitor. Similarly, if your determination of whether Mr. Woodyard is guilty of the above referenced crime as a complicitor should not affect your determination of whether Mr. Woodyard is guilty of the above referenced crime as a principal. You may find the defendant not guilty of the above referenced crime under both theories of liability, principal liability and complicity liability. Or you may find the defendant guilty of the above referenced crime as a principal, as a complicitor, or as both a principal and a complicitor. 13, a crime is committed when the defendant has committed a voluntary act prohibited by law together with a culpable state of mind. Voluntary act means an act performed consciously as a result of effort or determination. Proof of the voluntary act alone is insufficient to prove that the defendant had the required state of mind. The culpable state of mind is as much an element of the crime as the act itself and must be proven beyond a reasonable doubt, either by direct or circumstantial evidence. In this case, the applicable states of mind are explained below. A person acts recklessly when he consciously disregards a substantial and unjustifiable risk that a result will occur or that a circumstance exists. A person acts with criminal negligence when, through a gross deviation of the standard of care that a reasonable person would exercise, he fails to perceive a substantial and unjustifiable risk that a result will occur or that a circumstance exists. 14, certain words or phrases have particular meaning. The following are the definitions of these words and phrases. Conduct means an act or omission and its accompanying state of mind, or, where relevant, a series of acts or omissions. Act means bodily movement and includes words and possession of property. 15, the evidence in this case, the evidence presented in this case has raised the question of peace officer use of physical force with respect to manslaughter, reckless, and criminally negligent homicide. The defendant, Nathan Woodyard, as a peace officer, was legally authorized to use physical force upon another person if, one, he used reasonable and appropriate physical force upon another person when and to the extent he reasonably believed it was necessary to make an arrest, or two, he used reasonable and appropriate physical force upon another person when and to the extent he reasonably believed it was necessary to defend himself or a third person from what he reasonably believed to be the use or imminent use of physical force while making or attempting to make an arrest, such an arrest, I should say. You have been instructed that the prosecution has the burden of proving beyond a reasonable doubt all of the elements of manslaughter, reckless, and criminally negligent homicide, including that the defendant, Nathan Woodyard, acted recklessly or in a criminally negligent manner. You are further instructed that with respect to manslaughter, reckless, and criminally negligent homicide, the prosecution does not have an additional burden to disprove peace officers' use of physical force. You are instructed, though, that a person does not act recklessly or in a criminally negligent manner if his conduct is legally justified as set forth above. 16. The word cause, as used in these instructions, means an act or failure to act that in the natural and probable sequence produced the death of Elijah McClain. It is a cause without which the death would not have happened. If more than one act or failure to act contributed to the death, that each act or failure to act may have been a cause of the death. A cause does not have to be the only cause or the last or nearest cause if the act or failure to act joins in a natural and probable way with some other act or failure to act to cause some or all of the death. One's conduct is not a cause of another's death, however, if, in order to bring about such death, it was necessary that his conduct combine or join with an intervening cause that also contributed to the death. To qualify as an intervening cause, one, the intervening cause must not have been foreseeable. Two, the intervening cause must be one with which the defendant did not participate. Three, and the intervening cause must be one but for which the death would not have occurred. Simple negligence that contributes to the death of a person is foreseeable and cannot be an intervening cause. Gross negligence is unforeseeable behavior, and it may serve as an intervening cause. Gross negligence is abnormal human behavior that constitutes an extreme departure from the ordinary standard of care. 17, a person may act in self-defense if he reasonably believes that an officer is using or is about to use force that is not reasonable or appropriate. 18, it is the defense theory of the case that Mr. Woodyard did not cause the death of Elijah McClain. The defense asserts that Mr. McClain's death was caused by the injection of a dose of ketamine by paramedics and was therefore an intervening cause of death, which Mr. Woodyard would not have been able to foresee. 19, members of the jury, you may discuss this case only when you are all present, and you may only deliberate in the jury room. No juror should attempt to discuss this case with other jurors or anyone else at any other time except when all jurors are in the jury room. 20, if there has been or is any news coverage of this case, you must completely disregard it. Your decision in this case must be made solely on the evidence presented at trial. 21, once you begin your deliberations, if you have a question, your foreperson should write it down on a piece of paper, sign it, give it to the court's judicial assistant, who will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that under the law, the court is not permitted to answer. Please do not speculate about what the answer to your question might have been or why the court is not able to answer a particular question. 22, at the conclusion of closing arguments, the court's judicial assistant will escort you into the jury room where you will select one of your members to be your foreperson. Your foreperson will preside over your deliberations and shall sign any verdict form that you may agree upon according to the rules that I'm about to explain. The verdict for each charge must represent the considered judgment of each juror, and it must be unanimous. In other words, all of you must agree to all parts of it. Only one verdict shall be returned and signed for each count. The verdict form and these instructions shall remain in the possession of your foreperson until I ask for them in open court. After reaching a verdict, you will inform the court's judicial assistant, who will in turn notify me, and you will remain in the jury room until I call you into the courtroom. You will be provided with one verdict form. When you have unanimously agreed on your verdicts, you will select the option on the form which reflects your verdict, and the foreperson will sign the verdict forms as I have stated. I will now read to you the verdict form. You must not draw any inferences based upon the order in which I read them. The verdict forms you will receive, the verdict form actually you will receive reads as follows. At the top, it's People of the State of Colorado v. Nathan Woodyard, jury verdict. There's a Roman 1 at the top. It reads, "We, the jury, find the defendant, Nathan Woodyard, not guilty of manslaughter, reckless, and the lesser included offense of criminally negligent homicide." Beneath that, there's a signature line for the foreperson. Beneath that is Roman numeral number 2. And that reads, "We, the jury, find the defendant, Nathan Woodyard, guilty of," and there's 2 separate boxes. The first is followed by manslaughter, reckless, or the second box is followed by criminally negligent homicide. The instruction further explains that if you find the defendant not guilty of the charged offense and the lesser included offense, the foreperson should sign section 1 above. And there's a double asterisk beneath that. This is if you find the defendant guilty of the crime charged or the lesser included offense, the foreperson should complete only this guilty verdict by placing in ink an X in the appropriate square. Only one square may be filled in with the remainder to remain unmarked. The foreperson should then sign only section 2 above, and there's a signature line for the foreperson there. With that, I will allow the prosecution to begin their closing argument.
Just walking home. Grabbed him. Threatened him. That I'm going to change this situation. Certainly did. McClain walking home. He was dancing. As he told the defendant, he was stopping his music to listen. As he told the defendant, I'm different. I'm an introvert. Please respect the boundaries I speak. I'm just going home. Defendant, all the information you needed. Do the right thing. Elijah McClain told him in heartbreaking gasps sometimes, clearly and directly what he was doing and why. There was no need for this escalation of violence. There was no need to grab Elijah McClain while he was walking home from the store. The defendant told you that. On cross-examination, he said it would have been practical to just have a conversation with him. There was no need to threaten Elijah McClain that you were going to change this situation. He said, well, okay, when the defendant grabbed him and turned him around. There was no need for the defendant to work with his other officers, like Rosenblatt and Rodema, to take Elijah down to the ground. When they said, we're going to lay you down on the grass, Mr. Woodyard told you that that meant they were going to execute a takedown. That was the plan, the next step from the grab to turning him around to taking him to the ground. The only thing Elijah McClain had done is to explain exactly what was happening. I was stopping my music to listen and to tense his muscles because he was scared. And they're threatening to take him to the ground. And then they push him up against a brick wall. That sequence tells you everything you need to know about where the defendant's head was at on the night of August 24th, 2019. The word go. This was going to be an escalating physical encounter. And the defendant was trained and knew that that created risks. And when those happened, he just kept escalating further. Then after he knocks him unconscious with the carotid, the mask full of vomit from his face, saying, can't breathe, can't breathe, can't breathe. Who decided that it wasn't a medical emergency? Who decided that they didn't need to tell the paramedics about it? They told you it was him who made that decision. That changes the entire course of this encounter. Remember Madison Freeman, Elijah's coworker, came to talk to you? This photo was taken only a couple weeks before he was killed. It shows him in almost the exact same clothes that you saw, torn apart, covered in vomit, feces. All that was left, Elijah McClain's killed. He explains to the defendant who he was. The defendant didn't listen. He could have seen, if he'd stopped to listen and asked questions, who he was dealing with. He was dealing with the kid who was walking on his way home dancing, listening to his AirPods. And he told the defendant that's what he was doing. That he was walking home and that he was listening to his music and stopping it to listen. These actions in repeatedly escalating this encounter and in repeatedly ignoring his own training, that is what it means to be reckless. This is jury instruction 7. It's in that packet sitting right on your laps under your chairs. And I want to draw your attention to what it means to commit reckless manslaughter. And I want to be really clear about what it is not This is not a premeditated murder charge or even a murder charge at all. There's no allegation that Mr. Woodyard intended to kill Mr. McClain. That is not part of this case. This case is whether about he recklessly caused his death, whether he recklessly contributed to his death. And recklessly means consciously disregarding a substantial and unjustifiable risk. You all might have noticed at the end of my cross-examination with Mr. Woodyard, when I was showing him all those slides, I kept asking him the same question. You were conscious of this risk that Elijah McClain could die. You were conscious of this risk, all these different health complications that his use of force caused. That's why, because he knew all the risks, he disregarded them. That is reckless. Killed Elijah McClain. He also caused his death 4 different ways. The first, that this defendant changed Elijah McClain's situation in a way that led to his death. If the defendant doesn't make that threat and doesn't follow through with it, if he follows his training to de-escalate, to have a conversation when it's practical, Elijah McClain walks home. When the defendant chose to use the carotid control hold, the injuries that produced contributed to Elijah McClain's death. You remember this chart that we made with Dr. Mitchell? It's those same 3 injuries that we hear about from Dr. Buther too. The carotid control hold is designed to cause hypoxia, to cut off oxygen to the brain. That starts that hypoxic cycle. Elijah McClain is wearing a mask when he throws up. He's panting from the exertion of what the police are doing to him. And you can hear faintly on the audio this horrifying sound of him aspirating. Dr. Buther and Dr. Mitchell both talk about it. That prevents him from being able to clear his airway effectively, reduces the capacity in his lungs because they're full of vomit. Ultimately, it ends up in a situation where he's essentially drowning in his own vomit. And this also starts acidosis. Acidosis is that buildup of lactic acid in your system. You've felt it if you've ever done 2-day practices like Dr. Mitchell was talking about. And in order to clear that acidosis, you have to be able to breathe and be a super breather, like Dr. Buther said. If your lungs have vomit in them, you're hypoxic. And clear the acidosis. And just like the defendant is trained in his COCA slides, even a few minutes of acidosis can lead to a rapid deterioration of somebody's health. And you see that happening to Elijah McClain over the 18 minutes and 2 seconds between when this defendant grabbed him and he gets ejected. Third, the defendant's choice to think that Elijah McClain's repeated complaints, "I can't breathe," are not a medical emergency, killed him. Because if he tells Sergeant Leonard, not just we used the carotid, he went out, and then starts talking about all this administrative stuff about why they were doing what they were doing. If instead he says, this young man, a mask full of vomit, gasped out 6 times, can't breathe. I'm worried about him. We need to get this checked by the paramedics. We need to tell them what we are trained to tell them, that even a single complaint of I can't breathe requires medical attention and should be treated as an emergency. Fourth, this defendant contributed to and caused the death of Elijah McClain. He was complicit, he was part of, and he encouraged and aided Elijah McClain being pinned down in that prone position right before getting the ketamine and for those deadly couple of minutes afterwards. I want to talk about these things a little bit in turn, but before I do, no, I'm taking notes. My closing statement and the defense's closing statement aren't evidence. We're going to have the evidence with you back at the jury room. It's all those videos, it's all those photos, it's all those training slides. Even the mask, the clothing, if you ask to see it. So when I go through this, I want you to be able to look at the real evidence in this case. I don't want to hide it. I want you to look at it and to be able to know where to find what you're looking for. Because over the last 3 weeks, we've presented you with a lot of information. And so when I have these slides up, they're going to have these little red stickers on them. That's the number of the exhibit where you can go double check what I'm telling you. So if you want to write them down and take notes, you can refer to them later. If you see those timestamps, you'll see the name of the officer's camera, who it is, and the timestamp where you can go and double check everything that I'm telling you. And you can make your decision based on the evidence. Let's talk first about what the defendant did to change this situation. The defendant faced choices at every juncture of this, where he could either follow his training, de-escalate, have a conversation, work things out, or he could escalate. He could use violence, he could use threats. At every single turn, he chose to escalate. That is not what the APD requires of its officers. Policy 5.03. Deputy Chief Redfern came and talked to you a little bit about this. It is mandatory. Officers will attempt to de-escalate. Not may, not if they feel like it, not if they're feeling super relaxed that day. They will attempt to de-escalate their use of force whenever it's practical. You'll remember, I was cross-examining the defendant. I asked him about this initially on that. But there's no obvious threat. He's just walking down the street. It would have been practicable to just have a conversation. Pushback said, I don't know, maybe he's got a weapon. That would apply to everybody, come on. Really? There's no reason you couldn't have started off this conversation with, hey man, where are you going? What's in the bag? What are you doing? Eventually he admitted, yeah, it would have been practical to just have a conversation. They're trained on this. Use active listening. This might seem like a small thing, active listening. It's the kind of thing you might like read in a management training, or a therapist might tell you, or your partner might tell you. But they train police to do this, and it is ever so crucial. Because how else does an officer in the field figure out what's happening, except to be actively listening to the person that they are dealing with? They need to treat that person like a citizen, like someone, like a person, not just like a suspect that you can grab, manhandle however you want. The defendant said, you were trained to be actively listening. Yep. And you heard Elijah McClain say, well, okay, when you grabbed him. I don't believe I heard that at the time. What was the first words out of his mouth after you grabbed him? How could you not hear that? Because you're not listening. And that was a consistent problem, because if the defendant followed his training and listened to what Elijah McClain said, he had all the answers he needed. But from the moment he grabbed him, this conversation or this interaction was only going one way. He could have de-escalated, but instead, he chose violence. He knows that that wasn't the right thing to do, because that last quote, it would have been practical to just talk to him. When he grabs Elijah McClain, this sets in motion a series of important events. Mr. Woodyard admits that literally the first moment it would have been possible to grab Elijah McClain, that very first moment, he starts off with force. One of the reasons that's so problematic is that there's no explanation to Mr. McClain of why this is happening. Mr. McClain is trying to explain what's happening. He's trying to say, I'm going home. They keep saying, relax, stop tensing up. He explains to them why he's tensing up. I am an introvert. Elijah McClain is just a little bit different. You saw in their training slides how they're trained to deal with people who are different. And Elijah McClain explains exactly what he needs. Please respect the boundaries that I'm speaking. But the defendant disregards that training.
Favor, stop right there. Hey, stop right there. Stop. 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 I have a right to stop you because you're being suspicious.
Well, okay.
Turn around.
No.
Turn.
Defendant coming at him, saying, stop, stop, stop. Elijah McClain is. And nonetheless, Elijah McClain has the grace and understanding to just say, well, okay. He is expressing a willingness to de-escalate this. Talk it out. The defendant goes the other way. When Elijah says, please respect the boundaries that I'm speaking, you guys started to arrest me and I'm stopping my music to listen. In Mr. Woodyard's own words, he didn't respect those boundaries and instead responded with a threat to change the situation. He agrees that that was a threat. And so, of course, Mr. McClain is scared. He's being threatened by police that he was grabbed for reasons he doesn't understand. And his attempts to explain himself and what are going on are not being listened to and are not being respected. And instead, the defendant keeps choosing to escalate the situation.
They're gonna go well.
No, I am an introvert. Please respect
okay,
the
okay.
boundaries that I
Trying
am
to.
speaking. Relax. Stop.
Relax.
Stop. I'm going home.
Relax. I'm going to have to
Leave me
change this
alone.
situation.
The defendant knew about these risks. He was conscious of them. He was trained in his KOGA training. Remember, he's a KOGA instructor. This is not some newbie fresh out of the academy who doesn't know what he's doing, who doesn't know about arrest control techniques. This is somebody who is a certified KOGA arrest control tactics instructor. He knows that when you put your hands on somebody, that people will be scared, that they might tense up, and that that is an expected reaction. We even talked about the training slide with him where he admits, yeah, you know, just because somebody is resisting or tensing up, that's not a criminal action. That can just be somebody who's scared. is obviously what's happening here. Elijah McClain tries to explain further. He tells the defendant, I've got the right to walk where I'm going. I intend to take my power back. I intend to be centered. I intend to be centered. That's that big scary phrase. The defendant's still not listening to. The defendant had to de-escalate. If you look at that policy 5.03, it says that officers must use reasonable and appropriate force. That's not just in the policy, that's in the instruction of the law that the court gave you. That they must attempt to de-escalate when it's practical. And at the very end, the last page of that policy, they must arrange for timely and appropriate medical treatment. And those words at the end of that policy are right on. Because I suspect the defense is going to come up here and there and say, well, we called for the fire department, so what else could we possibly do? Well, tell them what actually the problem was, that he can't breathe and that he threw up in his mask. That's the big problem. That's what you're trained as a medical emergency. And what your policy says is that you have to arrange for timely and appropriate medical care. How can you get appropriate medical care to somebody when you're not telling the paramedics what the real problem is? You're not telling Sergeant Leonard, you're not telling the paramedics, you're not telling Sergeant Nunez that Elijah McClain couldn't breathe. Instead, we've got this series of events that all escalate this encounter. The grab, turning Mr. McClain around, threatening to take him down, pushing him against the brick wall, and then culminating in that carotid hole.
My name is Elijah McClain.
Ready to use karate.
I'm an introvert and I'm different. Oh no.
No, snoring.
I just
He
feel
wasn't
like
completely. He didn't lose consciousness.
I'm just different. I'm just different. It's awful.
He's actually losing the.
I'm so sorry.
You're gonna do.
I have no good. I don't do that stuff. I don't do. He's fighting.
The other guys are not here.
Why was
Slow
you
it down a little bit.
I don't do that. I want you to kill flies. I don't eat these. I'm not much saying. I don't judge people.
No, I mean, frankly, it's not walking up.
I try to
It's just a story.
speak with
When we showed him up,
and all right.
he was wearing a ski
And I
mask.
just click on it.
Elijah McClain had just been knocked unconscious by the defendant and the rest of his team with that carotid. And he's still explaining to them exactly what's going on, and nobody is listening to it. The carotid hole that the defendant did contributed to, helped cause Elijah McClain's death. It is part of that continuum that Dr. Mitchell was talking about that made Elijah so fragile, that put him in such a dangerous position before the paramedics absolutely inappropriately dosed him with ketamine. But when the defendant's actions put him in that position, when the paramedics also make a bad choice, it is so much more dangerous and so much more deadly. This is supposed to be the last resort. But Mr. Woodyard admits he should have just done it all differently. He admits, hey, I should have just talked to this guy. And he admits if he could, he'd take back that carotid hole. Because there wasn't a violent threat. Elijah McClain didn't have a gun. There were 3 200-pound officers on top of him, grabbing his arms. And all he wanted to do Officer Heineman and Officer Smith talked to you about how dangerous the carotid is if it's done improperly. And most importantly, how dangerous it is if you don't do the proper follow-ups. That's why you have to have a 100% success rate in your test in order to pass and be allowed to use this technique. The defendant got that training multiple times over the years and was also an instructor who was certified to assist in teaching this technique to others. They're taught don't do it more than once. But after Mr. Rosenblatt attempts it, then Mr. Woodyard does it too. And the risks go up if you do it more than once. They're trained there. And then crucially, they're trained in all the follow-ups. And I'm sure you all noticed this. But when Sergeant Smith is up there, or Mr. Woodyard's up there, and they start talking about these things, when they're talking about the requirements of the test and how the training works, it's 100%, you got to do it all, otherwise you fail. But then as soon as you start asking them questions that get a little bit too close, the screw-ups in this incident, then they're like, oh, you know, maybe it's not that important that you do all the steps. We could maybe skip some of them. But if they'd done that, they would have failed their training. Mr. McClain was not kept on his side in that recovery position. The very first requirement, lay on side, take pressure off. They did it for part of the time, not for all of it. Nobody checks Mr. McClain's pulse or his breathing. And this isn't a situation where, like, magically, if they checked his pulse, like, suddenly Mr. McClain is fine. That's not what we're telling you. Obviously, that's silly. The problem is that this is first part of a pattern of ignoring what they're trained to do. And some of those things are kind of dangerous, and some of those things are extremely dangerous. But this is also important because we don't know what would have happened. Elijah McClain's condition is deteriorating fast. If the defendant did what he's trained to do and tries to take a pulse, maybe he can't find one. I mean, Elijah McClain is still alive for quite a few minutes, so we know he had a pulse. But maybe it was so faint he wouldn't have even been able to find it. Maybe it was so erratic and jumping all over the place that even someone like Mr. Woodyard would have noticed. Or maybe it was hammering so fast they couldn't have missed it. And that's all information that could have been useful. Notify rescue while checking vital signs. There's no attempt to check the vital signs. And when they notify rescue, they only tell them half the story. We did the carotid and he's unconscious. Not, he's been pleading with us, I can't breathe, over and over again. Provide first aid. The defendant did nothing before he abandons Mr. McClain and walks off to go have his conversation with Sergeant Higgins. When he abandons Mr. McClain, he knows these steps have not been done by him, and they have not been done by Mr. Rebima or Mr. Rosenblatt. And that's the situation he leaves it in. He knows Sergeant Leonard has not been told about the vomit in the mask that Elijah McClain was aspirating, the mask the defendant told you he himself took off. He knows that Sergeant Leonard hasn't been told about the repeated pleas from Elijah McClain. I can't breathe. I can't breathe. Can't breathe. He knows they haven't checked Elijah McClain's coherency. When he testified, he said, well, I could hear him talking, but I don't know what he was saying. I wasn't paying attention. How can you say that you know if somebody is coherent if you're not asking them questions and paying attention to what they're saying? Sure, they searched him, and sure, they called Sergeant Leonard. They don't tell him the important information. And finally, the phrasing of this, again, is so important. It's not call fire and then abdicate all responsibility. Abandon your training. Abandon the person you just did the carotid to. It's have subject checked. Get them to do an assessment. Get them to check him out. He fails that too. And he tells you, I didn't feel the need to check for a pulse. Didn't feel the need to do all the steps this time. No, he knows better. And we know how dangerous the situation is. You're going to have the mask, access to it so you can look inside. You want to ask somebody to get some gloves to open it up and very carefully look inside of there and see how much vomit is in that mask. You can't. This is what it sounds like.
Okay, I've got his other arm. Okay.
That's that noise that I'm talking about.
Okay, I've got his other arm. Okay.
It's hard to hear in a courtroom like this, but when you play this on your TV, you can turn it up as loud as you want. Now, in terms of what effect this has on Elijah McClain, the medical experts are all really consistent. Dr. Buther and Dr. Mitchell both say that this causes hypoxia, aspiration, and acidosis. And Dr. Sina, he's sort of equivocal. He says, well, maybe it did, maybe it didn't. But there are reasons to trust Dr. Buther and Dr. Mitchell. Dr. Sina doesn't see live patients. And he agrees that if you're convinced that there was aspiration in the past, then that would have contributed to Elijah McClain's death. And he would then classify this case as a homicide. You are in much better position than Dr. Sina to evaluate this evidence. Because all he did was watch the videos for a couple of hours. You've heard the defendant's own statements. You've seen this video for 3 weeks. And you've heard from Dr. Buther, pulmonologist, who's the person best placed to evaluate this video footage. Despite Dr. Sina's sort of wishy-washiness on whether he is certain about aspiration, he still basically has the same cause of death as Dr. Buther. Before I put their pictures up there, are you even sure which one is which? That's how similar they are. It's the ketamine and the forcible restraint. The ketamine and the violent subdual and restraint by law enforcement. Despite all of that, if the defendant had treated Elijah McClain's pleas that he couldn't breathe as a medical emergency he was trained to, none of this happens. The training is clear. Any complaint, the very first line on the right side of that slide, any complaint regarding I can't breathe, potentially a sign of respiratory failure. The defendant admits he remembers hearing him say, I can't breathe. But rather than follow that training, the defendant decides this isn't a medical emergency. He says that, well, I took the mask off, so there's no more medical emergency. After I removed the mask, I didn't think he had any ongoing breathing issues. Did you check? Like the carotid training says you have to? But that's not even his job. The defense has been asking all these questions about, well, cops aren't medical experts. They're not trained to evaluate complex things like breathing. Exactly. That's why they give them simple training, which says any complaint of I can't breathe is a sign of respiratory failure. This is supposed to be out of their hands and told to the paramedics so that they can address the issue. I'm stalling here, Mr. Campos. I'm not sure what's up. Thank you. Back in academy, Mr. Woodyard demonstrates that he knows exactly what the issue is here. That it is not up to him to decide if somebody needs medical treatment for breathing complaints. That needs to go to the paramedics. but nobody gets told. Officer Smith says the same thing. We want to be updating rescue about even that one time saying, I can't breathe. And this causes the deterioration in Elijah McClain's health. Because before the defendant grabs him, he's fine. He's walking down the street and he's going home. But after the carotid, he starts developing that hypoxia. He starts developing that acidosis. He's aspirated vomit into his lungs. And his situation starts getting worse. This period of time is really important because there's no other thing that happens to Elijah McClain. It's the carotid. Then they've got him restrained and handcuffed in the recovery position until Mr. Woodyard comes back to the scene when the ketamine is about to be administered and afterwards. There's nothing else that happens. All the deterioration that we see in Mr. McClain's health is because of the carotid and this hypoxia and this acidosis caused by the defendant. And then Mr. Woodyard is there, encouraging and aiding his fellow officers, encouraging and aiding the paramedics. When they say we're going to use ketamine, when Redeema says, hey, Woody, Rosie, in a minute here, once this medicine kicks in, we're going to uncuff him and move to the gurney. The defendant says, yeah, it's on his gloves. And that's that complicity. Now, there are two ways that you can find the defendant guilty of manslaughter. One is what's described in the jury instructions as primary responsibility. That means he did the entire crime himself. That's what we've been talking about in these first three things. Any one of those, him causing the death through reckless conduct, that's him acting as a principal. That's him doing the crime of manslaughter by himself. The second way he can be guilty of manslaughter is the instruction you read called complicity, which basically means that you're encouraging or aiding somebody else or some other group of people who are doing the. So here we're talking about his complicity, his encouragement, his aiding of Officer Redeema and the paramedics in particular in the reckless actions they're taking. When Dr. Terashenko came and told you about how reckless the paramedics are, I didn't even have any questions for her. They did a real bad job. And according to complicity, they were part of that crime too. But so was this defendant. This is that complicity instruction. When another person or persons, so it can be a group of people, commit a crime, and the defendant purposefully encourages or aids them, that is complicity. And if you're complicit, you're just as guilty. The whole crime yourself. Officer Smith talks about how they train on this. You got to keep them in the recovery position. It can prevent aspirating vomit. The recovery position lets us look at somebody so we can see the change in their condition that we wouldn't be able to see if they were in other positions, like being pinned prone on the ground. Everybody agrees that when Mr. Woodyard comes over and he gestures to Mr. Rosenblatt, hey, let's go have a little conversation out of the range of the body-worn cameras here. And then when he's standing by the gurney, looking down at Officer Redeema and Elijah McClain, that's this period of time. Everybody says that's not the recovery position. Alicia Ward really didn't want to. She didn't want to admit that this wasn't the recovery position. Remember how she sat there? She cried, put her hands up over her face. She turned away from you. Wouldn't even look at you. She knew how bad, how dangerous this was. She knew that the defendant knew that too. And he had said yeah to this plan. Not just Officer Ward. Sergeant Leonard is standing right there and he says that is not the recovery position. It's not just him. Dr. Mitchell explains it to you too. From a medical perspective, this is not the recovery position. This is dangerous. This is contributing to his death. It is causing him to die. It is making the ketamine so much more dangerous. And the defendant was trained on exactly this. Get them out of the prone position. That's that third bullet point. When I asked the defendant about this, he said, it's important. I asked him if it's important to make sure they're in the recovery position. Yeah. It's important that they stay there. Not just that you start them in the recovery position, but they stay there. Yes, that is important. It doesn't do them any good if they start in the recovery position, then they end up prone. He's conscious of all of these risks. He's disregarding them all. They're killing Elijah McClain. He's trained about hypoxia. He's trained about how when somebody is prone, you can't expand your chest wall, you can't cough, you can't breathe effectively. That's what Dr. Buther and Dr. Mitchell talked about. And this is one of the slides that Sergeant Smith showed you that the defendant took. When I asked him about this, he says, yeah, I'm conscious of these risks. Yeah, I know that somebody can die these risks. That is exactly what happened to Elijah McClain. The second bullet point here describes the risks of acidosis that the defendant is trained on and that he knows about. When I ask him if he's conscious of this risk, that acidosis can cause this rapid spiral resulting in death, yes, he's aware of that risk. Because of that, you're conscious of it. Yeah, he is. You're aware of those dangers and that they get worse when somebody's on their side, somebody's prone. Yeah, he is. Now, in a couple of minutes, the defense is going to come up here and give you their closing argument. The one thing I want you to think about while they're talking to you is how that regretful, emotional, empathetic version of Mr. Woodyard that you saw on the stand, that is not the version that he presented to Mr. McClain. 4 years later, he has empathy about this situation, wants to understand. But that night, that was not who he was. He didn't listen to Elijah McClain. He said, well, yeah, I'll stop. He didn't listen. He said, I was stopping my music to listen. He didn't listen. He said, please respect the boundaries that I'm speaking. Ignored them. That is the version of the defendant that Elijah McClain got. And that version of this defendant is the one who caused his death. By ignoring his training, and ignoring Elijah McClain's pleas for help that he can't breathe. And ultimately by encouraging the defendant Redima's horrible plan. Keep Elijah McClain pinned down from before and after the administration of ketamine. The defendant knew about it.
Here,
I think that's
Rosie,
Yeah.
here in a minute, once this medicine kicks in, we're gonna uncuff him, put him on the bed,
Okay.
and then we're gonna restrain him, soft point him to the bed.
All right, let me grab some gloves. Okay.
No, you're okay, I got it. Like that cuff right here, dude. He's not coming because they just arrested that homicide suspect in District 1.
did?
They did, so, they're busy, so.
Just put on his gloves to help. He turns his head over, looks down at Elijah McClain. His eyebrows go up. He almost gasps in a little bit. He sees exactly what is happening. He's doing nothing. Stop it. Mr. Woodyard, you agree with that plan, Officer Redema? Yes. Officer Woodyard, did you even put on your gloves? You could help. Yes. He's encouraging, aiding, getting ready to jump in and help, all while he looks down and sees exactly what is going on with Elijah McClain. And it is exactly the story he was trained to avoid. That's why he's guilty. Manslaughter.
And there's roughly 20 minutes left. Close for Mr. Woodyard. Yeah. Well, yeah, can I have counsel approach? Folks, we're going to take a short break. I was just discussing timing with counsel, and as I said, I've allowed each side 70 minutes to make their closing arguments. So we'll take a brief recess at this time. I'd like to have you back in 15 minutes or less if possible, but I think it's a good time for a short break. So don't form or express any opinions yet or discuss the case. Do independent research and avoid any press coverage. All right, our jurors have stepped out. Be back in 15 minutes.
At the screen, just to make.
Oh, yeah. Yeah, let me check that for you here. It looks like it's working.
Screen like that. No, you don't see that. I was gonna ask if you're gonna leave the screen like that. Yes. Okay, thank you. You can move it. I'll just leave it here. Appreciate them.
The court will recall People v. Woodyard. We ready to bring the jurors back in for the defense closing arguments? All right.
Make it a 10.
Oh, yeah, sure. All right, the jury is returned. Please be seated. The court will recall People v. Woodyard. Jury's back. The parties and counsel are present. Mr. Ho, you may begin your closing argument, please.
Elijah McClain matters. It does. And the world was a much better place with him in it. We need to end in custody deaths. There's been too much violence. And the world will be a better place when that happens. These are important. These important facts don't conflict with the fact that Nathan Woodyard did not kill Elijah McClain. There's a lot of anger involved in this case, and there should be. Someone died. That's important. But the anger isn't only on one side of this room. Nathan Woodyard entrusted Elijah McClain to the care and custody of his fellow officers. He entrusted Elijah McClain to medically trained professionals. Elijah McClain died. That matters. Nathan Woodyard did not kill Elijah McClain. He's not responsible for what other people did or did not do. This trial has not been about Nathan Woodyard, and it needs to be. This entire trial, all the witnesses that have been testifying about other people. It has been about what other people were doing and what other people were not doing. And they just want him to take the blame. This is Nathan Woodyard. This case is about Nathan Woodyard. This is his trial. And we need to talk about him and not others. He was assigned the call. He was there. But he did not kill. Ketamine is what killed Elijah McClain. It was the ketamine that killed Elijah McClain. That's what this entire trial should have been about. This fact has been repeated over and over and over every time an expert took that stand. They all testify that it's the ketamine. Now, the government has done everything they can to muddy and to call into question that simple fact. But you know what happened. It was fire that responded to the scene. It was fire that decided in less than a minute and a half of arriving on the scene to give Elijah McClain ketamine. It was fire that decided to give him an overdose of 500 milligrams of ketamine, despite being explicitly trained not to do that. It wasn't a random number. It wasn't everyone shouldn't get 600. Everyone shouldn't get 300. It was right on the nose of what fire decided to do within a minute and a half of arriving on that scene. And just like that, right after Elijah McClain received that ketamine, I heard Dr. Terashenko say he suffered a cardiac arrest. His heart stopped. He stopped breathing. Before the ketamine, none of those were an issue. Elijah McClain overdosed. And then it was fire who then tried to write in the report that they simply miscalculated his weight. The math still doesn't add up. They had truly miscalculated his weight the way they said they did. It would only be 425 milligrams of ketamine. We said in the beginning that there are people guilty of killing Elijah McClain, but they're not here. They're not here today. Nathan Woodyard is in this room today. Nathan Woodyard is in this room because he was assigned the call. But he did not kill. He did not kill Elijah. They know this. And they know that they have to prove to you that there's no other real possibility. No other real possibility exists other than that Nathan Woodyard killed Elijah McClain. They realize that they carry the entire burden in this case. And it's up to them to take out that real possibility. And just like Judge Warner said at the very first day of trial, I told you, you look to this table. You look to this table for the evidence. Because us, Mr. Woodyard, we could be playing pinochle throughout the entire trial. And you're still to look to them. They're the ones that have to bring the evidence. And their evidence cannot leave the real possibility that Nathan did not kill. Their evidence cannot leave the real possibility that Nathan did not know that the paramedics would come in and overdose Elijah McClain with ketamine. Their own evidence is telling you that the ketamine is what killed Elijah McClain. You heard Mr. Slaughauer talk about Dr. Sina's testimony. He's the one who did the autopsy. of Elijah McClain. He's the one that put eyes on Elijah McClain. And he told you all, I believe I stated in my opinion that but for the ketamine, he would be alive. I don't have any other injuries to say otherwise. He also says, he was asked, without the ketamine, we don't have death. That's my opinion. Without the ketamine, we don't have death. That's my opinion. Oh, and by the way, your pulmonologist agrees with me. Who is that pulmonologist? Dr. David Buther. He took the stand. Dr. Buther told you that he's never testified as an expert before in a criminal case. They chose this case for his very first time. And what did he say? And so if we need to define the cause of death, we need to define the cause of death in one word, we would say ketamine. I think I previously testified that if we walked up to Mr. McClain and he's healthy and injected him with ketamine, more likely than not, he would have died from that dose. And he summed it up perfectly. He summed up their entire case perfectly with this next quote. It's like you're making a chicken dish and the ketamine is the chicken. It's not the same dish if you have just chicken, but without the chicken, it is not the dish. The ketamine is the chicken. It's not the same dish if you have just chicken, but without chicken, it is not the dish. This is the dish they want you to make. Take out the ketamine, you don't have death. Without death, it's not guilty. Without ketamine, it's not the dish. Without ketamine, it is not guilty. Last witness they put on the stand was Dr. Roger Mitchell. Here's what he had to say about the ketamine. You've always said this was an overdose, right? Well, I don't know if I've always said it, but you're right. It was an overdose. An overdose of ketamine can kill. That is correct. I'm not going to say that the ketamine alone would not have killed him. This is their evidence. Every single expert they put on the stand, it's the ketamine that killed Elijah McClain. Now, Dr. Mitchell was highly critical of the police actions in this case, as he should be. Those videos are hard to watch. They're heartbreaking. They're not actions by Nathan Woodyard. The doctors never identified Nathan Woodyard. Why? No one singled out Nathan Woodyard. Unlike Dr. Terashenko, who back in 2021 was asked to analyze specific individuals, paramedic Coopers and Chikuniak. Not those doctors, not the other doctors that testified. Those other doctors were not asked to analyze Nathan Woodyard's actions. Instead, it was always law enforcement as a whole, law enforcement as one. And that's because they can't single out Nathan Woodyard. They can't single out a single act that Nathan did that caused death. It has to be in combination with everyone else. Did they mess up? Did they say, oh, we just forgot to ask the right question? You heard that these doctors have testified on this matter a number of times now. You heard that they testified in those other officers' trials and that they testified in other hearings. They didn't screw up. They didn't mess up. They're not looking at Nathan Woodyard. They're looking at all the other police officers. There's a lot of anger involved in this case. One thing you should do when you go back in the deliberation, once you determine whether you should believe their experts and believe it's the ketamine, then you should take a look at jury instruction number 16. That's what we call the intervening cause instruction. Once you determine that the government failed to disprove ketamine as a real possibility of Mr. McClain's death, you should look at this instruction. In other words, they need to show you, they need to prove to you that there's no realistic way that ketamine was the cause of death. And if they can't do that, jury instruction number 16 provides a lot of guidance. Because the next thing you'll do when you look at jury instruction number 16 is you're going to determine whether the paramedic's injection of ketamine without doing an assessment, whether the injection of 500 milligrams of ketamine was a gross deviation from the standard of care of paramedicine, of medicine by a paramedic. And if you remember what Dr. Terashenko said yesterday, how many times was she asked, and how many times did she say yes? To a degree of reasonable medical certainty, actions by paramedic Cooper and paramedic Jacuniak fell below the standard of practice for a paramedic. Slightly below, significantly below, every time she was asked that, significantly below. And like Mr. Slothauer said, he didn't have any questions for her because that's uncontested. That's not up for debate. There's no one that's come in here and said, no, we disagree with that, because they can't say that. So you then turn during instruction 16. And that was like a gross deviation from the standard of care. You need to ask yourself, was it foreseeable for Nathan Woodyard? Could Nathan Woodyard have known? Could he have reasonably foreseen that the paramedics would come on the scene, would come next to Elijah McClain, stand there, not ask him a single question, and then within a minute and a half say, okay, we'll give him ketamine. Get me 500 milligrams, despite what they're explicitly told not to do. Second step, you need to determine that Mr. Woodyard did not participate in that. Is the act of calling for medical participating in thinking that, oh, well, of course, they're going to significantly overdose Mr. McClain without doing an assessment? The act of calling for paramedics, the act of calling for Aurora Fire for law enforcement is the same if we pick up the phone and call 911 after them. Are we liable if paramedics come and decide to significantly overdose the individual you called 911 for? Same principle applies. Now, when we're talking about looking for evidence, do you think for 1 second, with them pulling his test scores from back when he was in the academy, that they wouldn't have loved to show you anything that says that Nathan Woodyard has experience with ketamine, that he's ever been on a call where someone overdosed from ketamine, that he's ever been on a call where Aurora Fire even gave ketamine. Remember, this was less than a year old. They didn't have ketamine in rotation very often. Is it just that they forgot to show you this? Or is it because they don't have anything to show that Nathan could have possibly known that Aurora Fire is going to give 500 milligrams of ketamine? Finally, the third one. Do you disbelieve all the evidence, all the uncontradicted evidence in this entire case? Every single expert had said, without the ketamine, we don't have death. You hit each of those, then that's not guilty. He's not responsible for other people's inactions. He's not responsible for the paramedics' decisions that day. Paramedics caused the death under jury instruction 16. Then Nathan Woodyard is not guilty. This is a real possibility. If they fail to disprove that to you, he's not guilty. And that's it. Check the box. Go home. Now, if you're unable to determine that consensus, if you're unable to reach a consensus on that, then you still need to analyze and determine whether Nathan Woodyard caused the death, not the paramedics. That scene over the course of the last 3 weeks saw a lot of witnesses, and a lot of these witnesses carried years and years of knowledge. They went through so much school to perfect their craft, schooling upon years of practice. And all these experts disagree as to the effect of the restraints employed by Officer Redema, Rosenblatt, and Green. Not one of those experts, except for Dr. Nadia Tereshenko, discusses Nathan Woodyard because he's not there for the restraints. These experts all use terms that we've heard throughout the past 3 weeks of like, possibly, I can't rule it out. It may exist, but I can't prove it. All those are in relation to hypoxia and metabolic acidosis. Now, in terms of aspiration, they all agree it happened. And the vast majority of them, pretty much all of them, agree that when the aspiration happens, you cough like mad. You cough like crazy when you begin aspiration. As you've heard by many of them, we've all probably had that experience. If I take a swig of my water right now and start gagging, you guys would be like, yeah, been there, wrong pipe. Give him a few minutes and he'll recover. And all of them agree that unless you're sedated, you're going to be coughing. Really, the only time when you don't cough when that happens is if you get knocked out by an overdose of ketamine and you're unable to protect your airway. But none of them can seem to agree as to when it happened. Now, Mr. Slothar stood up here and talked about the mask and the aspiration in the mask. Not one of them talked about it being that was the case. It was there's a risk that could occur, but we can't say it happened. And when you asked each of those individually, Dr. Sina, Dr. Tereshenko, Dr. Arnall. Experts all conflict. Say, listen, I didn't actually see the vomit. I didn't actually see when he vomited in the mask, but he's talking. He's talking afterwards. He's not coughing. So no, that's not aspiration. Aspiration likely occurred when we see the video of Mr. McClain when he has, as Dr. Tereshenko put it, no muscle tone. And he's leaning forward on the gurney. And as they pull him back, you see all the vomit and slap come back and hit him in the face. They don't want to talk about that. So when they're talking about possibility, I can't prove it happened. There's a risk. They're not talking that way about the ketamine. That they're sure about. The other stuff, they're not. The other stuff, when they're using those terms, they're telling you there's the real possibility that that didn't happen. But here's the thing. This case doesn't require you to determine which expert to believe. As mentioned, these are highly educated experts who spent years perfecting their craft. You heard each one of them testify and say they spent hours upon hours. We talked about 50 hours, more than that, reviewing the body camera footage, reviewing all the different angles. All these days, all these weeks, all these months spending over the body cams, analyzing it, talking about it. About an incident that Nathan Woodyard experienced less than 7 minutes. But unlike the experts, Nathan Woodyard doesn't get the luxury of viewing the different angles. Unlike the experts, Nathan Woodyard doesn't get to hit the rewind button. Sergeant Smith, Sergeant Leonard, Dr. Tereshenko, they all came in here and told you the police are not medically trained. This is what Sergeant Smith said regarding the training. The reality is they only receive basic first aid training, right? Yeah, the same type that anyone in a cubicle can get if they go to the Red Cross. It's the exact same program. Sergeant Leonard says, we don't even keep up with that. All we're taught is CPR and tourniquets. That's a separate training. You have a wound. They know how to apply gauze on it. They're not trained to spot acidosis, hypoxia. And even all those experts who are trained to do that, they can't agree. What they're trained on is you call for medical assistance. You call their version of 911. Sergeant Smith, do you actually want your officers to be making medical diagnoses, doing medical intervention? Oh gosh, no. 'Cause what if they get it wrong? We don't know what's going on. We don't have any more medical knowledge than the average citizen. The issues related to hypoxia, acidosis, aspiration, these are all highly technical medical terms. These things where the experts can't agree. Because if it was that easy, if it was as easy as the attorney generals want to make it sound, like based on 2 slides, if it's that easy to spot, they would not have needed to call so